Okay, so general provisions of partnership. So first we discuss the definition of partnership. It's found in Article 1767 CC, meaning the Civil Code, because partnership is governed or under the Civil Code of the Philippines. It has already been discussed in the course Law 231, or the first law of business law, that there are different kinds of divisions of law here in the Philippines. And first kind, one division is the Civil Code. So partnership is under the Book of Civil Code. So here's the definition of partnership: a contract wherein two or more persons bind themselves to contribute money, property, or industry to a common fund, with the intention of dividing the profits among themselves. So take note of the definition. It's very clear that there is a contribution of money, property, or industry, meaning service. So industry is the profession of the person, or the skills, or his ability or time to manage the partnership. And there is the last rule, that their binding to themselves is purposely to divide the profits that they will make in the course of the business. In some instances, professionals form also a partnership. So they are called the general professional partnership. This is found in paragraph 2 of the article 1767. So when two persons or more than two professionals, like for example, dentists or doctors or lawyers or certified public accountants, will form a partnership among themselves, this kind of partnership is known as general professional partnership, or commonly known as GPP. So what are the elements of a partnership? So the general partnership. So there shall be a partnership whenever there is meeting of the minds. So meeting of the minds is the agreement among the persons or the partners who are intending to form a partnership. So there's agreement among themselves. Number 2, there must be a common fund formed. So how is the common fund formed? Distribution. Not distribution, but contribution. Contribution of money, or contribution of property, or the contribution of service or industry. And number 3, there is intention that profits, including losses, will be divided among them. So without these 3, there is no partnership. Okay? An example of this would be when two persons agreed to contribute money in order to buy a lottery ticket. And once they will win, or they will hit the jackpot, they are going to divide the dividend or the prize. So that kind of intention between these two persons has been ruled by the Supreme Court as a partnership. Okay? So what are the essential features of a partnership? Number 1, there must be a valid contract. Of course, the contract would be the articles of partnership. So the partners, I mean the persons, when they form a partnership, there should be there is already a contract, and that contract is intended to fulfill a lawful object. It's found here in number 4. There must be a lawful object, meaning the purpose, meaning the intention is to make business which is within the bounds of the law. So if because if the parties in a contract will agree to form an illegal contract or illegal or unlawful objective, there is no valid contract. Okay. Number 2, the parties who are entering into the contract of partnership must have legal capacity. Again, who are the persons not legally capable or not legally capacitated to give consent to enter into a contract? These are the minors. They're not allowed. Insane persons, demented persons, disqualified by law, and those who are imprisoned for more than 6 years, which we call as persons suffering from civil interdiction. So these persons are not legally capable or legally capacitated to enter into a contract, specifically contract of partnership. So again, in number 2, the parties or the partners should be legally capacitated to enter the contract. And number 3, there must be a mutual contribution of money, property, or industry to a common fund. So I've discussed this already in the previous topic. Number 4, there must be a lawful object. So again, the objective of the partnership is to have a legal business, to make a legal business, not illegal. And number 5, the purpose or primary purpose must be to obtain profits and then divide the same among parties. Now, in case of loss, again, divide the losses among the parties. So these are the essential features of a partnership. Also required of the partnership is that once the articles of partnership is made, the articles of partnership is the contract, it must not be kept secret among the members or the partners. Otherwise, if it is kept secret, then the partnership is not known as a partnership, but an association which has no legal capacity and governed only by the provisions of co-ownership, which is in Article 1775 of the Civil Code. Now, co-ownership, what is co-ownership? It is when a thing is owned by, the thing is undivided and is owned by numerous persons. Okay, that's co-ownership. And there is no intention to divide the profits. Now, what is being kept secret among the members? It simply means that the articles is not open to the members or the partners, no, but not to third persons. So when this happens, there's no partnership, but only co-ownership exists. Okay. So what are the characteristics of a partnership? So number 1 is usually contractual in nature. So in the definition alone, it states that it is a contract, you know, between two or more persons. So it is essentially a contract. Number two, once a partnership is formed, there is a separate juridical personality also being formed. This is stated in Article 1768 of the Civil Code. We'll discuss that later. Then number three, there is the doctrine of delectus personae, which will also be discussed later. But in advance, delectus personae is the principle where the partners are given the right to choose whom to engage business with. No, they are given the right to choose the person that they be associated with. No, sa Bisaya pa, ang partners tagaan og right mo pili kinsa ilahang mahimong partner. The number four, there is the doctrine of mutual agency, which is in Article 1803. And number five, the liability of partners in the partnership would be personal. What is that personal liability means? It means that if the partnership assets are no longer capable of paying or settling the debts of the partnership, so there is more liabilities than assets, then the creditors of the partnership will compel the partners to pay the debts of the partnership from their personal assets, from the personal assets of the partners. Okay? So the personal assets of the partners can be taken by the creditors of the partnership in case the partnership debts cannot be paid by its assets. Gets? Okay. Okay, let's go to the form of partnership. Now this is discussed in Law 1 or Law 2314. The different kinds of forms would be oral, written form, or public instrument. No? Public instrument is one which is notarized or acknowledged by a notary public. So the general rule in terms of form of partnership contract is there's none. No, there's actually no form required of a partnership contract in order to be valid. It's stated in Article 1356 of the Civil Code. But when is this actually required to be in writing? So here, a partnership is required to be in writing when here, if the partners would contribute immovable property. No? So the general rule is that there is no form which is required in order that the partnership be valid. And here are the exceptions. Number one, if immovable property or real rights are contributed to the partnership, meaning the partners, one of the partners contribute real property or real rights. So in this case, there must be a public instrument. The contract must be of a public instrument, meaning it must be acknowledged by a notary public. Also, number two, when then in case where immovable property or real rights are contributed, it also is required of an inventory of the property which is contributed must be attached to the public instrument. No? And this inventory must be signed by the parties. So again, if the partners will contribute immovable property or real rights, these are the requirements. Must be in a public instrument. Number two, there must be an inventory of the property contributed and signed by the partners or parties, which is attached to the public instrument. So the public instrument here is the articles of partnership. So otherwise, if this is not being made or followed, then the contract will be void. If it's void, no legal effect. No? Another exception to the form is when the contract falls under the coverage of statute of frauds, meaning to avoid fraud, the contract must be in writing, no? Not necessarily in public instrument. So when is this? When there is a contract, there's an agreement that the contract will be performed in more than a year, beyond a year, or when the lease contract is more than 2 years, so it should be in written form. So that's number two. Number three, so when the capital of the partnership is 3,000 or more than 3,000 pesos in money or property, stated in Article 1772 of the Civil Code. So in case of number three, the law requires that it must be that the articles of partnership must be in public instrument. Again, acknowledged by a notary public. And second requirement, that it must be registered with the SEC, or the Securities and Exchange Commission. No? Although in number one, movable property contributed, this also requires registration with the SEC. No? It's not stated here. Registration with the SEC. Now, the governing agency of partnership is Securities and Exchange Commission. Although, even here, it's stated with the SEC opinion in June 1960 that for purposes of convenience in dealing with government offices and financial institutions, meaning the banks, so registration of partnership even with capital less than 3,000 pesos is recommended. No? Okay. So in Article 1784 states that a partnership begins from the moment of the execution of the contract, meaning the agreement of the contract, unless it is otherwise stipulated. So the birth of a contract of partnership or contract of partnership, yes, is when there is an agreement between the parties or the signing of the contract. So if you are asked when a partnership begins its personality, then here's the answer. Article 1784, execution of the contract. Unless there is contribution of immovable property, which there are requisites, public instrument, inventory, otherwise it is void, or when it's under statute of frauds, or where the capital exceeds more 3,000 pesos. Okay. So now we will discuss the theory of separate juridical personality. Now, once a partnership is formed, another person is being made juridically, meaning legally there is another person. Let's say, for instance, person A, Mr. Amado, and person B, Mr. Bayani. Amado and Bayani agreed to form a partnership. So if you are asked how many persons are there, you know, so there is including the partnership, there are already 3 persons: Amado, Bayani, and the partnership. Why? Because the partnership of Amado and Bayani has a separate juridical personality. It can stand on its own, and it is distinct from that of each of the partners. So even if in case of failure to comply with Article 1772, meaning this one, the 3,000 pesos, Article 1772, even if they failed to comply with the notarization of the articles of partnership or registration with the SEC. Now, as a juridical person, a partnership may acquire and possess property of all kinds. So, if the partnership will buy a property, so that property can be registered under the name of the partnership. Number 2, it can incur obligations, meaning it can apply for loans with financial institutions or banks. Number 3, it can bring civil or criminal actions, meaning it can sue in a case in the court of law, no? In conformity with the laws and regulations of their organization. So this is a juridical person. So like a corporation, it is also a juridical person. So that ends the discussion on separate juridical personality. Now let's discuss the principle of delictus personarum. Now I have already discussed a while ago that delictus personae is the right of a partner or any person for that instance, the right to select or choose the person to whom he can be associated with. No? So it's already that is delictus personarum or delictus persona.